Thank you for joining us for today's online talk, which will be starting shortly now. For those of you who are here early, thank you for waiting patiently. Thank you for joining us again for today's online talk. And our title of the talk today is Understanding Land Fraud in Malaysia. My name is Vincent Cheng, and I'm a Senior Associate at Mawing White and Associates. And today, I will be your moderator for our session today.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Before we start today's talk, let me introduce the firm and what we do. Mawing White Associates is a mid-sized law firm that was founded in 1985 by Datuk Mawing White. Our able team today comprises 37 lawyers and a support team of 30. Datuk Ma today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families alike. This group indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. And today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly talks at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue now, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please do contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have two speakers for today. Allow me to introduce them, Denise Pang and Noel Aoyang. Denise will speak on the first two talk points, and Noel will speak on the two remaining points. Now, allow me to further introduce Denise and Noel. Denise is our partner in Dispute Resolution Department who leads the land dispute team of the firm. She graduated with Bachelor of Laws with Honours from the University of London, and she was then admitted to the Malaysian bar in 2015. She's well-versed in land, planning, development, infrastructure, construction, and environmental laws. And Denise was named as a Rising Star in 2022 by Asian Legal Business Malaysia, Thomson Reuters, which recognizes young lawyers under the age of 40 who have been making an impact in Malaysia's legal scene. At the same time, we have Noel, who is an associate in our dispute resolution departments. She graduated with Bachelor of Laws with Honours from the University of Essex. She was admitted to the Malaysian bar in 2020, and she completed an LLM in bar professional training at City, University of London, and was called to the Bar of England and Wales, Lincoln's Inn, in 2019. Noel's areas of practice include construction law, land disputes, and intellectual property law. First, on the first two top points, land registration under the National Land Code, and also common fraudulent transaction and scams. Whereas Noel will then continue with case analysis on land fraud and as well as best practices to safeguard land ownership. We will then conclude with a Q&A session. Without further ado,
thank you, Vincent. Thank you for registering for our talk today and joining us today. So I'm going to start the talk today to give a brief introduction about the land registration under the National Land Code. So what's the National Land Code? The National Land Code is basically the legislation governing all lands in Malaysia, or at least Semenanjung. Because in Sabah and Sarawak, they have the different legislations. They have the Sarawak Code and the Sabah Ordinance. So they have different land codes, but at least for the National Land Code, it does apply to Semenanjung, Malaysia. So regarding today's topic, why is it important? According to this last year's news article published on 28th May 2024 by The Star, nearly 500 land scam cases are detected over the last 3 years, which is 2021 to 2023. And it was actually on the rise, according to Bukit Aman, the police department. So what does this tell us? Even in this day and age, there are still land scam or land fraud cases ongoing. 500 might seem like a lot, but if you think about it, there are out of the total hundreds and thousands of transactions, 500 is not much, but still very serious. Because if you are a victim of these land scams and land frauds, it will definitely affect you very seriously. So how do we prevent this? I think let's just have a look at the next slide. So land registration is actually supposed to prevent this. Land registration refers to the process of recording the land ownership, transactions, and rights of the public. And this register is maintained by the government, aka in Malaysia, the Land Office. So the Land Office will have a complete record of all the land titles that are issued or alienated to landowners. So in Malaysia, all lands are owned by the state, which means if you are from the state of Selangor, the Sultan of Selangor, state of Selangor actually owns all lands. But the state will give out titles to each individual or landowner, be it individuals or companies. And you can either get a freehold title or a leasehold title. And leasehold in Selangor normally is about 99 years. Like I said, the National Land Code is the key legislation governing land registration in Semenanjung, Malaysia. And it establishes the land registration system. So the National Land Code actually sets out all the duties of the Director of Lands and Mines, the duties of a land administrator, which is the one who is supposed to keep record, the registrar of titles as well, and other land officers in the Land Office department. So why do we have this land registry? It's actually very simple, and it's under section 340. It says that any title or interest of any person or body for the time being registered as the proprietor of any land, shall, subject to the following provisions of this act, this section, be indefeasible. Which means if your name is registered as the landowner on the registry, the Land Office registry, it means that your title cannot be disputed. So if, let's say, for example, the land title says Denise Pang as the landowner, that is like final and conclusive proof that I am the owner of the land. So the term indefeasible was actually defined by the Privy Council in the case of Fraser against Walker. These are actually UK cases. Since Malaysia was previously colonized by the British, so we have actually adopted British land principles. So indefeasibility means immunity from attack by any adverse claim to the land or interest in respect of which he is registered, which a registered proprietor enjoys. So it basically means that whatever, if your name is on the title, it's final. So then Malaysia, in codifying, in enacting the National Land Code, we also actually followed the Australian model. So in the UK, previously, they did not have the torrent system, what we call the torrent system. Torrent system actually was adopted from Australia, where a record of all land titles are being kept by the Land Office. So now in Malaysia, if we come back to the Malaysian context, each state in Malaysia has its own land office. Every state has different rules regarding lands. Let's say, for Selangor has different rules from state in Malacca. So as a lawyer, we need to be familiar with all the different rules in different states, because at the end of the day, the state owns all lands, which means all lands in the state of Selangor, for example, belongs to the Selangor Sultan, and all lands in the state of maybe Perak belongs to the Perak Sultan. Like I said again, registered titles, conclusive proof of ownership, but there are actually three exceptions to this indivisibility of the title, which means that there are three instances where people can actually challenge your land title. And one, it is under section 340, sub 2 of the National Land Code. A, in any instance of fraud or misrepresentation. B, if the registration was obtained via forgery or by means of an insufficient or void instrument. I'll go on to let you all know what examples of this later on. Fraud and misrepresentation. Later on, my colleague Noel will be illustrating this in a case of Bunsun Bunyanyit. So it basically, in that case, it was an impersonation of the landowner. So someone impersonated the landowner and sold off the land. That's a case of fraud and misrepresentation. And B, where there is registration obtained by forgery. And then there is also, later on, we'll elaborate more on a case called Tan Yin Hong, where a power of attorney was forged in order to sell the land. So there are many instances of cases like this. Even there are many documents that people can forge. For example, an NRIC, people can forge your IC. People can forge MOT, Memorandum of Transfer. We can also seen cases where court orders itself are forged and are fake. So these are by means of forgery or an insufficient or void instrument. If that document or instrument, what it means here, instrument is a document that is not right, that has been forged, means that it's void, is invalid. So therefore, the sale or the transfer to you was not legitimate, and therefore you don't own the land, even though you're named as the landowner. And the last exception, C, is where the title or interest was unlawfully acquired by the person or body in the purported exercise of any power or authority conferred by any written law. This actually is very simple. It means that if the government or any officers unlawfully acquired your land, so unlawfully took your land, forfeited your land, then that transaction can also be set aside. So these are the three exceptions under the section 340 of the National Law. So now this slide, what I wanted to show is actually the history of land registration in Malaysia. So back in the 1950s, 1960s, it was all manual. If you all seen the old titles, it's actually on yellowing round brown paper, and that pieces of paper is actually as big as your table. So A3 size, and it's browning. So those are very old titles, and endorsements are all handwritten. These titles, some of it are handwritten. Endorsements are also handwritten and physically stamped. Nowadays, land titles, we only have 2-3 pages. It's electronically generated. So from 1966, we moved on to 1980, where's this system Penghutan Hasil Tanah, where what they call cukai land taxes, quit rent. Quit rent is being imposed on owners. And then we moved on to 1995 when they started to computerize the records of land office records. So in 2025, then we moved on to system e-Tanah, where everything is uploaded and centralized with the internet. Until now, so system e-Tanah is practiced until now, of course, with various improvements and upgrading. But there was actually a huge spike in land fraud cases when the physical manual land titles were converted or computerized in the 1990s, 1985 up to 2000, because a lot of records were actually lost. So physical land records are actually very prone to, number one, physical paper attracts what you call silverfish, which means it's a type of worm that eats paper. So the paper will actually crumple over time. So there are a lot of problems with physical records, which is why it was digitalized. And also papers go missing. That's what happened a lot in the land office those days as well. But now we have computerized and system that is available online as well. We can do searches, land title searches online now, which is fantastic, because last time we had to queue and at the land office, take a number, sit down, wait for a very long time before we can actually do a search in the land office. Now everything is much more faster. So importance of land registration, like I said, it protects your land, and it also at all persons having an interest in the land. So this would include the banks. If you, let's say you charge your land to the bank, this include banks, this include if you lease your land to someone else, these meaning that you let your land for more than 3 years. Anything less than 3 years will be a tenancy. Or if, for example, this land is being held on trust for beneficiaries of a will or of a trust. So in those circumstances, all these persons who has an interest in the land can actually record their interest on the land title itself. So this serves as a notice to everybody that, look, besides the land title, this land also has persons interested in it, the bank, a beneficiary, and a leaser, or to that extent. So it serves as a notice to everybody. And if you want to purchase this land, note that these are encumbrances of the land. This land is encumbered, and these are the persons interested in the land. Of course, again, land is also a very important and limited commodity. So it's valuable as well. And some people use their life savings even to invest in lands, which is why land has to be protected and well protected in that fact. And we should definitely safeguard it from land fraud, which comes to my next point, prevention of fraud and disputes. So once we have central registration system, it is less likely for fraud cases to occur. So in the olden days, if you just imagine without a registry or a record of land ownership, if you were owner of the land and then somebody came to you and said, oh, I actually own the land next to you. Do you want to buy the land? And then they'll give you a title. There's no way of you verifying whether or not the title is authentic or whether or not this person really is the landowner of the neighboring land. But now, if let's say this situation happens now, you can actually do a search at the land office and you can actually find out the landowner's details. And if the person who's telling you that they are the landowner, if the particulars of the description, the name, NRIC, address doesn't match, then you have to be very careful that it might be a land fraud situation. So the land registry also ensures transparency, reduces conflict. So now it also facilitates property transactions. So like I said, because land is so valuable, nowadays land transactions is actually assisted by conveyancing lawyers. Nowadays, sale of land is actually quite protected if you hire a lawyer to safeguard your interest throughout the sale and purchase transaction. So what your lawyers can do, they can do land searches for you. They can draft your SPA and they can actually prompt you when to pay. For example, hand over the keys and etc. So all these things, the land registry actually helps lawyers, conveyancing lawyers, to smoothen the transaction for the sale or mortgages or even inheritance, for example, remittance. If let's say your relative passed away and they want to transfer the property from the deceased to the beneficiaries. So these property transactions actually benefit from the land registry. It also supports economic development. So if you in Malaysia, this would be good for investors. Investors will have confidence in the Malaysian land registry system. And this would encourage foreign direct investments. For example, in Malaysia nowadays, there are many lands purchased for development of data centers, malls, factories, etc. So this would actually improve the Malaysian economy. And even if, for example, banks, if you have a business opportunity and if you have a land, and you want to charge the land to banks to get a loan in order to focus on other business opportunities. So the loan will be approved much faster once the bank is able to access all these records. If not, if we don't have a centralized record, the approval for bank loans might take a long time and you might just miss out on a business opportunity. So these are the importance of the land registration system. Now we move on to common fraudulent transactions and scams. So I guess this is the main gist of why we are here, how land fraud cases occur in Malaysia nowadays and what scams should we look out for. So what we see now in Malaysia, quite common, they are actually fake land titles. So we have, for example, in one case, a client of mine received a letter from another person claiming to be the landowner of their land. This is the exact same land. And if I look at my client's land title, it's all in order. This is the land, for example, it measures 2 acres. And when you look at the land title that was given by the other party, the particulars of the title is different lot number, different title number, but based on the plan that is attached to the title, it seems to be the exact same shape, exact same measurement. So what's wrong here? So there might be, and that, of course, the other person said they purchased it from someone else. So when there's 2 fake and competing land titles, then we have to actually refer the matter to court, and the court will decide which title came first, which title is invalid, and which title is the authentic one. So what we do is we do a tracing exercise, and parties will have to go to court to prove that their ownership of the land. Now, so that's fake land titles. The second scenario, forged signatures and documents. So like I said, we have various documents that can be forged, from your SPA to your MOT, your NRIC, your power attorney. Power attorney is a document where you sign to give a right to someone else to sell or deal with the property. This is very common if, let's say, the landowner is overseas and they sign a power attorney to appoint someone else to deal with the land or to take care of the land on behalf of the landowner. Even court orders, there was this case where the court order for the transfer of the land was actually fake. So if you do a search at the courts of Malaya, you can actually go to court and do a search and see whether, based on the case number, see whether there is actually this court order that has been issued. And it turns out it was not a valid court order. So all these documents can be forged, and typically it's quite hard to detect. So what you do need to do is do a lot of background checks and to make sure that everything fits and everything is in order. If there is some discrepancy in the details, I think that's a red flag, and definitely you need to be very careful about that. The third one is identity theft. For example, impersonating a landowner. I won't talk more about this. My colleague Noel will cover that later. The fourth scenario is actually quite common as well. Authentic signatures obtained by fraudulent means. So what do I mean by that? So it might be a case, so not only people that you don't know might scam you or defraud you, people that you do know can also scam and defraud you. So in these cases, there are cases like, for example, there's an illiterate mother who signs certain documents, and these documents are actually the memorandum of transfer to transfer land to her son, so one of her sons, whereas this land should have actually been passed on to several of her kids, but one of the sons actually got her to sign a memorandum of transfer to transfer it only to him. So that's an example. But the mother is illiterate, which means she doesn't know how to read or write. So that's why she signed. So that was actually a case that our firm handled. So we had to sue the son, and this old lady had to attend court and say that although I signed this, yes, but I did not know, I was under the impression that this was for something else, and it wasn't for the transfer of the land. So then we have to sue the son, get the land back. So that's a real case. And then the next scenario is, for example, inheritance and estate matters. So again, another example, this landowner passed away, and his son actually went to the land office to say that, oh, I'm his sole and surviving son, so therefore please transfer the land to me. So the land office did, and this can be done via the small estates board. So what it did, the land office transferred the land to the son, and then thereafter the son transferred it to his wife under love and affection. But unknown to the land office, this deceased landowner actually had one son and 3 daughters. So the daughters are technically also entitled to the land, but unfortunately this son went to the land office and defrauded and signed invalid. So you can actually, yes, misrepresented himself as the sole beneficiary. So in this case, now the siblings of that son would have to sue his wife to get back the land. So these are instances where, again, people that you know can actually commit land fraud as well. The last example is actually corruption or abuse by government officials. This rarely happens, but it did happen for certain occasions. For example, like I said earlier, when the land office documents was actually digitized. So there were a lot of land fraud cases where when they digitized it, they changed the landowner's name to themselves or to someone that they know, and then they sold off the land. So that was one period. But even recently, there was this deletion of land office records for lands that were dormant or abandoned by government officials. So the police are currently investigating that case, very high-profile cases. The MACC will be involved, corruption charges will be charged. These government officials will be charged for corruption. So this technically some of the more common fraudulent transactions and scams in Malaysia. So now there are also actually cases where trespassers, so persons who are unaware, and technically they said they bought the land and built their houses on the land, but later on they realized they were defrauded by a non-existent person, and they were actually trespassing on lands belonging to others. So again, these are all very common if you are not careful. So whenever you enter into a land transaction, you want to buy or you want to sell land, it's very important for you to act cautiously and to check all the documentation. So later on, my colleague will also brief you all on the preventive measures that you can take. I think that's all for my session. Noel, I'll pass it on to you.
Thank you, Denise. Hi, everyone. My name is Noel, and I'll be the second speaker for the second half of the talk today. I'll be doing some case analysis on land fraud and also talking about the best practices and preventive measures to safeguard the land ownership. Okay, we'll now first talk about the National Land Code, Section 340, subsection 3. So this subsection says that the land titles shall not be defeasible in cases where the title or interest was acquired by any purchaser in good faith and for valuable consideration. So previously, my colleague Denise talked about subsection 1 and subsection 2 of the National Land Code, section 340 of the National Land Code. Subsection 1 says that the title or interest of any person or body of the time being registered as proprietor of any land shall, subject to the following provisions, which is subsection 2 and 3, be indefeasible. And subsection 2 says that the land titles are defeasible in cases of fraud, forgery, and misrepresentation, etc. So now we'll talk about the subsection 3 and also some case analysis on these subsections. Now, the first case will be Adorna Properties. Now, in this case, the federal court held that section 340 of the National Land Code conferred immediate indefeasibility. This became the subject, so this federal court decision became the subject of many criticisms, as it has caused some injustices to the landowners who were defrauded of their lands. Now we go on to the facts of the case. Now, the respondent, who is Madam Bunsem Bunyanit, was the registered proprietor of a piece of land which has been sold and transferred to Adorna Properties, which is the appellant in this case. Now, Madam Bunyanit claimed that her signature was forged by the vendor, which is a seller who sold and transferred her land to Adorna Properties. The respondent, Madam Bunyanit, filed a claim in the High Court for her to be restored as the registered owner of the land. And the High Court then dismissed the claim. So then she appealed to the Court of Appeal, and the Court of Appeal reversed the High Court's decision and restored Madam Bunyanit her rights to the land. Now, Adorna Properties appealed to the Federal Court again, and then the Court of Appeal's decision was reversed in favor of Adorna Properties. So the Federal Court unanimously held that the proviso in subsection 3 exclude all purchases in good faith and valuable consideration. So now, in this case, Adorna Properties' title over the land enjoys immediate indefeasibility as it has purchased Madam Bunyanit's land in good faith and for valuable consideration. Now, this is despite the fact that her signature on the instrument of transfer had been forged by the vendor. So now you can see this is why the High Court's decision or the Federal Court's decision in this case had been very unpopular and also was criticized by the public. So now we go on to the second case, the case of Tan Ying Hong. So in this case, the Federal Court overruled the case of Adorna Properties, which we talked about earlier, and held that Section 340 confers deferred indefeasibility. So deferred indefeasibility means that the subsequent purchases of land acquired by means of fraud or forgery, where they were found to be acting in good faith, have purchased the land for valuable consideration, would be afforded an indefeasible title to the land, meaning the subsequent purchasers will hold indefeasible title to the land and not the original owner. So now we'll go on to the facts, talk a bit about the facts of the case. So in this case, Tan Ying Hong, which is Mr. Tan, was the registered owner of a piece of land in Kuantan. So now the first respondent, who was purportedly acting under a power of attorney granted by Mr. Tan, executed charges in favor of the third respondent, which is the bank. Now, the purpose of these charges was to actually secure loans amounting to 300,000 for the second respondent. However, Mr. Tan was not aware of the existence of such charges until the bank actually issued a notice of demand to him. Now, Mr. Tan claimed that his signature was forged and that he had not signed any power of attorney, and therefore the charge instruments executed in favor of the bank was void. Now, so Mr. Tan then filed a claim in the High Court seeking, among others, a declaration that the state charges were void. Secondly, an order expunging the register and the issue of document of title, the memorial of charges against the land. And thirdly, an order directing the bank to deliver up to him the issue document of title to the land. So the High Court found that Mr. Tan had never granted the power of attorney to the first respondent, and therefore the first respondent actually had no authority to charge the land to the bank. So the registration of Mr. Tan in the issue document of title was found to be obtained by fraud and forgery. Now, in this case, despite making such findings, the High Court was bound by the decision of the Federal Court in Adona Properties, and the bank was actually held to have obtained an indefeasible title. Now, in Adona, despite the fact that the signature of Madam Bunyanit on the instrument of title had been forged by the vendor, the Federal Court held that by virtue of the proviso to Section 340 sub 3 of the National Land Code, any purchaser in good faith for valuable consideration enjoyed immediate indefeasible title to the land. So therefore, Adona Properties' title over the land enjoys immediate indefeasibility, as Adona Properties had purchased Madam Bunyanit's land in good faith and for valuable consideration. So now in this case, the High Court's decision means that despite the court's finding that the registration of Mr. Tan in the issue document of title was obtained by fraud or forgery, because Mr. Tan had never granted any power of attorney to the first respondent. So despite all that, the bank still obtained an indefeasible title to the land. So this was the High Court's decision. Now, Mr. Tan was unhappy with the High Court's decision, of course. So he appealed to the Federal Court. And the question that was raised in the Federal Court was whether Section 340 of the National Land Code confers upon the registered proprietor or any person having registered interest in the land an immediate or deferred indefeasibility. Now the Federal Court will have to think about whether Adona Properties case was correctly decided, and also the proper construction or interpretation to be accorded to Section 340 sub 1, 2, and 3 of the National Land Code. So now the proviso after the Section 340 sub 3, which states that provided that nothing in this subsection shall affect any title or interest acquired by any purchaser in good faith and for valuable consideration, or by any person or body claiming through under such purchaser. So now, in answering the question here, the Federal Court held that Adona Properties had been incorrectly decided. So the proviso after subsection 3 of the National Land Code is directed towards subsection 3 alone and not to the earlier subsection, which is subsection 2, which talks about the fraud, forgery, and misrepresentation and unlawfully acquiring the land title. In this case, the court held that the application of the proviso after subsection 3 was restricted to subsequent purchasers of the land, not immediate purchasers. In this case, a party who finds itself in the same position as Adona Properties, who is an immediate purchaser, to the vitiating circumstances in subsection 2, could not rely on the proviso in subsection 3 to claim that his title is indefeasible and avoids its title or interest from being impeached. And this court says that only the subsequent purchasers of land can rely on the proviso in subsection 3. So in the case of Tan Ying Hong, it was not in dispute that the charges executed in favor of the bank by the first respondent was based on void instruments, the bank being the immediate holder of the charges and not the subsequent purchaser or holder of interest cannot rely on subsection 3. And the fact that the bank had acquired the interest in good faith for value was not an issue because the charges arose from void instruments. Mr. Tan's appeal was allowed in this case. So now we'll go on to talk about, sorry, let me talk a bit about this case. Let me conclude the case. So in this case, it was held that federal court in the Adorna Properties case has misconstrued section 340 sub 1, 2, 3, and 3, 2 and 3 of the National Land Code, and thus come to the erroneous conclusion that proviso in subsection 3 applied equally to subsection 2. So this is an error that needed to be remedied forthwith in the future in the interest of all registered proprietors. And the decision in Tan Ying Hong brings relief to landowners as the risk of losing their lands over the vitiating circumstances stated in subsection 2 has been lowered. However, it must also be borne in mind that landowners are unlikely to recover their lands from subsequent purchases if it can be shown that the land has been purchased in good faith and for valuable consideration. Okay, so now we'll talk a bit about the case scenario. Let's refer to the first owner, who is A, party A. The first owner of a piece of land, who is party A, who then transferred the same piece of land to party B, and which is through forgery instruments, through void instruments, through fraud, forgery, or void instruments. So in this case, B's land title that was transferred through forgery, fraud, or void instruments will be divisible under section 340 sub 2 sub B. So far as section 340 sub 1 of the National Land Code is concerned, A's title to the land is totally indivisible. He's the original owner. So in short, if A's name appears on the registration, no one can come and claim for that title, so the law will not entertain it at all. So in this case, if B, whose name appears in the register, if it can be shown that the title or interest obtained by B was obtained by fraud or misrepresentation or forgery or void instruments by him or anyone else to which he was not party or privy, then his claim to the title or interest can be defeated. Like I said earlier, it's divisible under subsection 2, 300 subsection 2B. So similarly, under subsection B, was that it was proved that it was obtained through forgery or insufficient or void instrument is the same. The second part of this case scenario, so this is another instance where under subsection 340 sub 2 sub C, where B's title could not be defeated if B actually purchased the land through X under good faith and true valuable consideration. So any title or interest gained by any person subsequently so if B cannot prove that he actually purchased the title by good faith and true valuable consideration, then the title will be divisible as well. The important point here is good faith and valuable consideration. So under subsection 3, after the proviso after subsection 3. Now we'll move on to the third case study. Previously, we have been talking about good faith and valuable consideration. So there are some exemptions to the doctrine of good faith, actually. In this case of T. Sivam, the court held that the existence of good faith or otherwise would depend on the particular facts of each case. So it depends on each of the circumstances of the case. And the overriding consideration here is the particular circumstances of each case. So in this case, the court held that good faith does not mean absence of fraud, deceit, or dishonesty. It also requires acting honestly, reasonably, or fairly. The second point here is it is not enough for a purchaser to merely show absence of fraud, deceit, or dishonesty. So if there is a knowledge of a dispute as to the ownership of the land, or there's a knowledge of fraud. So if you know that there is a dispute of fraud arising from this land title, and you still purchase the land, then it is not enough to show good faith, even though you are not a party to the fraud. The third point here is that a purchaser in good faith does not include a purchaser who was careless or who had been negligent. And then the fourth point is the elements of good faith are not closed. It must in all cases depend upon the circumstances of the case. Again, the issue here is, the main consideration here is the court will have to look at each of the case and look at the circumstances of each case. Now, in relation to valuable consideration, the Court of Appeal in the case of Midland Banks held that valuable consideration requires no definition. It is an expression denoting an advantage conferred or detriment suffered when purchasing the land. So this is another case where it talks about not only a fraudulent purchaser, but also a fraudulent lawyer and fraudulent property agent. So this case, I would say, is a bit more extreme. The defendant here was the owner and seller of a large piece of land and was desirous to sell the piece of land. The plaintiffs were failed prospect, meaning a potential buyer who was unable to conclude an agreement with the defendant to purchase the land. Now, prior to these negotiations, the plaintiffs have allegedly demonstrated their commitment to pay the deposit of 1.2 million to the fraudulent property agents. This deposit has never been remitted nor paid to the defendant, who is the owner of the land, and had always remained in the possession of the agent. Now, during the negotiations, the defendant had actually rejected all the drafts SPA because the drafts did not reflect the preliminary agreed terms and conditions, including the actual purchase price. The property agent and also the lawyer acted conspicuously and dubiously, where they insisted that the draft SPAs reflect the actual purchase price of 40 million, when the prior agreement between the defendant and the plaintiff was actually 60 million. Now, therefore, these negotiations have failed. The defendant's rejection were clearly recorded and communicated to the property agent and also lawyer. And since the negotiations have failed, the defendant have subsequently sold the land to another third party, which is unrelated to this transaction, for purchase price of 58 million. So now in this case, despite knowing that the draft SPAs have been rejected and the whole transaction has been rejected and failed, the fraudulent property agent and the lawyer, and to some extent also the plaintiffs, hatched a fraudulent scheme in order to secure the interest that they would have gained if the negotiations with the plaintiffs were successful. The three fraudsters' modus operandi was to fabricate. They were trying to fabricate a facade and false narrative as if the plaintiffs were well within their legitimate expectations. The plaintiffs were the buyer, the potential buyer, that they were well within their legitimate expectation to rely on the ostensible authority of the fraudulent lawyer and fraudulent property agent. So to say that the defendant, who is the owner of the land, has actually agreed to one of the draft SPAs that was prepared by the fraudulent lawyer. Now, without the defendant's knowledge, the lawyer and property agent colluded and accepted one of the sham draft SPAs, which has led to the plaintiffs to sign the SPA. So this SPA was actually prepared by the fraudulent lawyer. The plaintiffs were insisting that the fraudulent lawyers and the fraudulent property agents' acceptance purportedly would bind the defendant as principal. So the fraudulent lawyer and the property agent allegedly had accepted a further deposit of 4.8 million, which was paid to the fraudulent lawyer's firm from the fraudulent plaintiffs. So this is another facade employed in the machinations to fraudulently force the defendant to commit and conform to the fraudulent or sham SPA that he has never agreed to. So after that, the plaintiffs even filed a suit against the defendant, seeking for damages and specific performance to force the defendant to perform the sham SPA. And the plaintiffs even lodged caveats on the defendant's land to protect their fraudulent interest. While defending against the plaintiff's claim, the defendant also filed a counterclaim for the plaintiffs to remove the caveat, the fraudulent caveat, and also sought for damages for the removal of the caveat and damages against the property agent, the fraudulent property agent, and also lawyer. The High Court then dismissed the plaintiff's claim and allowed the defendant's counterclaim against the three fraudsters. So in this case, it shows that not only will there be a fraudulent purchaser or buyer, there can also be fraudulent property agent and also fraudulent lawyer. So you need to be more careful when dealing with all these transactions. You need to, like my colleague Denise said earlier, you need to do a lot of background checks, even on property agents and also property lawyers. And also lawyers. Now we'll move on to some Malaysian news on land fraud or fraudulent transactions in relation to land. So in this case, it's August 2024 case news. So in this case, a fraudster behind a major land sale scam since 2016 has swindled victims out of over about 550,000. The suspect's tactic was to present a fake sale and purchase agreement to the targets and claim there was significant interest in the land. And this suspect would also show a power of attorney that purportedly allowed him to represent the owner. So all these cases, sale and purchase agreement and also like power of attorney, you need to be very careful when signing them or dealing with them. And the next Malaysian news happened in January 2025. There was an ongoing probe into the illegal land transfers, which has led to the arrest of 7 district and land office workers. So the syndicate paid insiders to exploit the system by deleting land ownership records. So in this case, even government officers like land officers or 7 district and land office workers, they can be paid to delete land ownership, to do some fraudulent acts as well. We need to be extra careful when even dealing with land office. So now we'll move on to the preventive measures when dealing with land ownership. So the first one would be strengthening documentation, the use of digital records for land transactions, or verification of land titles and ownership through a centralized database. You need to deal with the documents, and the land office would have to digitalize their records for land transactions so that they can be traced easily afterwards if there is anything that's going wrong with the transaction, the land transactions. So now the second one would be public awareness, educating the public about land fraud schemes and how to spot them. So you need to be more aware of the land scams or land fraudulent transactions in relation to land that's happening around you. Attend more online talks like this to know more about how all this land fraud happens and also how to prevent them. The third point would be legal reforms, improve laws and regulations surrounding property transactions, increasing penalties for fraudsters. This is for the lawyers and the legal, something to do with the legal side of the society. Try to improve the laws and regulations, set higher penalties for fraudsters. This would also lower the rate of all these land fraud transactions. Now, the last one would be technological solutions, using technologies such as biometric verification and digital signatures to prevent fraud. So in Malaysia, there's actually a rule. So when the transaction amount exceeds the threshold, the land office would require the parties to be present for biometric verification. So like for the Gombak land office, it would be about 1 million, and Selangor land office would be 5 million. And also Hulu Selangor actually requires biometric verification for all land transfer transactions. The other states may have their own threshold, or some states may not even have implemented this biometric verification at all. This is also one of the preventive measures that they should be taking. Now, practices to safeguard ownership. How do we safeguard your ownership of your land? So you need to conduct a visit to the subject land or property. You also need to verify the property's existence, location, and state. So paid a visit. Fraudsters would actually or usually profit from buyers skipping this step. So you need to go and visit your land before purchasing any land. Second point, verify the legitimacy of land titles through official land officers. Examine every document pertaining to the property, including like zoning permits, tax receipts, and title deeds. So make sure they are current and genuine, and verify that the seller is actually a rightful owner by looking through official documents or records. So for the third point is avoid dealing with untrustworthy intermediaries or agents. Fourth one would be engage a valuer to value the land if the purchase price is substantial. And the last one would be consult a lawyer before entering into any land transactions like bankruptcy and running up searches, court searches, etc. on the seller. Now, one additional red flag is that the deals that look too good to be true, so the purchase price that is way below market, or like vendors who want fast or urgent payments or inadequate paperwork, should also all be avoided. You need to ask questions about a seller acting under a power of attorney as well. These are typical signs of fraud. You need to ask a lot of questions, do a lot of background search. So conclusion is that, so land fraud is a very serious issue, even in Malaysia, with significant economic, social, and legal consequences. And a multi-pronged approach is required, including legal reform, public awareness, and technological intervention. And every one of us, from individuals to government agencies, must work together to combat land fraud in Malaysia. That is all from me. I'll pass the floor back to Vincent.
Thank you very much, Denise and Noel, for your insightful sharing in this topic today, understanding land fraud in Malaysia. Thank you very much to both of you. Now, we have had quite a few questions from the floor today, so we will now take turns to answer these questions from the participants from the Q&A chat box. So the first question that we have here today is from an anonymous attendee. So the question, is there a difference between a regular land search and an official land search? Some land searches have that chop from the land office at the bottom. Who can conduct these searches? Planner, lawyer, regular folk? To Denise, would you like to answer this question?
Sure, thanks, Vincent. So both searches can actually draw from the same database at the land office. The main difference is that, of course, the official land search is naturally, it costs more because it has the chop on it. I think it's 50 ringgit, but if you do a private search, it's actually just 30 ringgit, and it just lists down the particulars of the land, but without the land office chop. Certain applications require the official land search, and some, for example, an application for a lost title. So that one, you do need to do an official search. And if, let's say, for example, if you're submitting documents into court, the best proof would be an official land search as opposed to a private land search. That the official land search bearing the chop would bear more weight in the eyes of the court. And then the second question, who can conduct these searches? Actually, anyone can do it, but you do need to pay to do it. You can actually either go to the land office, or you can actually register online on the eTana online system. Once you register an account, you can actually do a land search. So I hope that answers that question.
Thank you very much, Denise, for answering the first question. As for our second question, we have a question from Ms. Putri Liana Mardia. Hi, is it possible for the purchasers to claim that they are not aware of the details of their land purchase, i.e. the type of property that they have bought, bracket, even though lawyers are involved in the process and representing the purchasers or developers? Noel, would you like to answer the question?
Okay, so for the answer of this case, if the purchaser, I would say that if the purchaser is a bona fide purchaser with good, so he purchased the property by good faith and with valuable consideration, the transaction will still go on. So even though, like I said earlier, even though lawyers are involved, if you can prove that you actually bought the purchase price with, if you are a bona fide purchaser, then the transaction can still proceed actually.
Thank you, Noel, for answering the question. As to our third question, we have a question from an anonymous attendee. Who and what role does the Federation of Land Commissioner play? Denise, can you take this question?
So the Federal Land Commissioner, actually it's the Federal Land Commissioner, FLC, is the landowner. It holds the title for the federal government. So any lands belonging to the federal government will be registered under the FLC. So state, like I said earlier, all land belongs to the state. Then how does the federal government own any land? So technically the state can actually issue titles to the federal government and register it under the Federal Lands Commissioner. For example, in more recent scenarios, I can give examples. If there is an acquisition of land for federal government projects, for example, it should be a highway or a railway project, or even for water pipe facilities. So when land acquisition occurs, the state will acquire the land on behalf of the government. Then subsequently, the state will have to issue titles for these acquired lands to the Federal Land Commissioner. So Federal Land Commissioner, the lands owned by federal government is not registered as federal government land, it's registered under the Federal Lands Commissioner. So that's the role and function. Thank you.
Thank you, Denise, for the insightful answer. Then we have another question from an anonymous attendee as well. Is power of attorney to transfer land still applicable or relevant these days? Noel, could you answer that question, please?
Okay, short answer would be yes. So in Malaysia, a power of attorney is still applicable and relevant for various legal matters, including the transfer of land. But the use for transferring land has specific limitations and requirements. Some land officers are actually very hesitant to accept the power of attorneys as a mean for transfer of certain types of land. So for example, in Malaysia, the Malay Reserve land. And in Kelantan specifically, any transfer, charge or lease through the power of attorney given by a Malay to a non-Malay is incapable of registration. And in Kelantan, it specifically states such power of attorney is void. The process of transferring land ownership in Malaysia generally requires certain formalities to be completed, which might include like the signing of the actual transfer document, stamping and registration. And yeah, thank you.
Thank you very much, Noel, for the detailed answer. Now, while we have a few more questions from the floor, and we thank you for your passionate participation today. Due to time constraints, we are able to answer only one more question. And the last question that we are answering is from Madam Hidayah Nasir. Is transaction for Tanah Lidi also considered a land fraud? Denise, are you able to take that on?
Sure. So for those who don't know, Tanah Lidi is actually a huge piece of land, for example, a 5-acre land, but it's actually being subdivided unofficially by the owners and then sold to separate individuals and corporations. So there's only one land title for this 5-acre land, but this 5-acre land can actually be maybe subdivided into 10 plots and then sold to different people. Tanah Lidi is technically the purchasers of this unofficial subdivided plots, actually all beneficial owners of the land itself. And technically they are recognized by the law, but these beneficial owners, their rights are a bit hard to exercise because everything you do is subject to the consent of all the other beneficial owners. And if let's say this beneficial owner, his name is registered on the title itself, then he is actually a trustee that holds the land on trust for all beneficial owners. It's also a nightmare when one of the beneficial owners pass away. So if let's say 5 acres of land subdivided to 10 plots, one of the owners passed away, his beneficiaries, maybe 5 of them, will then be the beneficial owner of that subplot of land as well. So then basically the number of beneficial owners will keep multiplying and increase. So that would be a nightmare. So technically, Tanah Lidi is not a scam or a fraud, but it's just a very unpractical way of holding land or owning land. So another example I think I can say about this, we had a case where it's Tanah Lidi, but this land was actually acquired by the government for a highway project. So now this land is actually registered as an agricultural land, but the owners on the land has moved on to do their own things on the land. Some parts of the lands are still used for agricultural purposes, but some parts of the land are used to build factories, build buildings and factories and workshops. So when the land was acquired, the land administrator did not award any compensation for any buildings that were built because the buildings are technically in breach of the category of land use, which is agricultural. So no compensation was paid for the demolition of all the factories and the workshops and the buildings. So that's the owner's risk and the owner's loss. And also, if you breach this land use, condition of land use, technically your land is also subject to forfeiture by the state. The state can actually take back your land because I say that this land is supposed to be used for agriculture, but you use it for example, industrial purposes. You have not followed that condition, I'm going to take it back. And when land is forfeited by the state does not pay any compensation. So that is also very risky. And other practical concerns, like for example, this land cannot also be charged to the bank. So if you only own a subplot, you cannot charge the entire land to the bank and get a loan facility. So it's not a scam, but it's a very tricky situation to be in. So owners of Tanah Lidi should actually apply to the land office to officially subdivide the land. But there are complications. You must hire a surveyor. So number one, the question is who's going to bear the cost of the surveyor? And then number two, you need to track down all beneficial owners to consent to that subdivision application. So that is the way out for a Tanah Lidi. I hope that helps your question, Hidayah. Thank you.
Thank you very much, Denise, for that insightful response. Now, we hope that you have already benefited from our session today. Thank you to Noel and thank you to Denise too. Now, before we conclude, I have just a couple of announcements to make. Firstly, please join us again for our upcoming talk 2 weeks later on the 26th of March, Wednesday, where we will be talking about divorce, insights on the law of division of assets between couples. This will be presented by our lawyers, Jasmine Wee, Alyssa Dalila, and Aisha Rahim. All right. Secondly, please fill in our feedback form and tell us what you thought of our talk today. The link to the form will be posted in the chat. Thirdly, do follow and like our social media accounts. And fourthly, if you would like to just speak with our lawyers, we do offer complimentary consultation up to 30 minutes over the telephone or over a video conference. please fill in the form on our website. The link is posted in the chat box above. Now, to all guests, thank you for joining us today. We hope that you have had a good time, and today's information, you will find it informative and useful. Thank you, everybody, and see you on our next talk. Goodbye.